This is St. Louis on the Air from St. Louis Public Radio. I'm Sarah Fensky. A $495 million verdict against the makers of a popular baby formula. A St. Louis man on death row given a deal to save his life, only to see it rejected by the Missouri Supreme Court. A gym in Ellisville that found itself under investigation by state officials after allowing a transgender woman to use its female locker room. Those are all topics for today's Legal Roundtable, and today we're joined by three top attorneys willing to help us make sense of the judicial system and some of the biggest news stories coming out of it here in St. Louis. And so joining us today is Booker T. Shaw. He's a former justice on the Missouri Court of Appeals Eastern District, and he is now a partner at the Thompson-Coburn Law Firm. Booker Shaw, welcome back.
Great to be here, Sarah.
And we're also joined today by Bill Freivogel. He's a professor of journalism at Southern Illinois University, Carbondale, and also an attorney. Bill, welcome back.
Hi, Sarah.
And last but never least, again today we are joined by Sarah Swadesh, a labor and employment attorney who's in private practice at the law office of Sarah Swadesh. Sarah, welcome back.
Thank you.
So a St. Louis jury recently returned a $495 million verdict against Abbott Laboratories. They make a popular baby formula called Similac. It was fed to a preemie at Cardinal Glennon. The baby developed a severe illness. This is called necrotizing enterocolitis. And her family's lawyers claim it was because she was fed this formula, which include cow's milk. The jury, 9 of 12 members of the jury agreed, and they awarded $95 million in compensatory damages and $400 million in punitive damages. Sarah, this formula was given to the baby by the hospital. No one is alleging it had been tampered with or that it had gone bad or even that you're not supposed to feed this formula. How do we end up getting to a verdict this gigantic?
Well, I didn't get to sit through the trial, but my guess is the plaintiff's lawyers put on, so first of all, there's a dead child. There's a lot of sympathy there. The jury is going to want to take care of the family. And then after that, as far as why it got to $400 million, $95 million, I'm assuming the plaintiffs had an expert or more than one expert, and I'm assuming they put on evidence of some link of the formula not being appropriate for that age of baby or something in the formula, some chemical compound that maybe shouldn't have been there. And then lastly, they probably got into Abbott's financial status, saying, Abbott, you know this chemical compound is in there. It shouldn't be in there. You made $1.2 billion. Hence, the jury comes to $400 million. I'm sure there's some calculus in the jury's mind that I don't know about that they got to the number.
And the idea is we need to get the attention of this big corporation. If we're just coming back with $2 in nominal damages, that's not going to get their attention the way $400 million, that actually affected their stock price. That's how big a verdict this is.
Oh, that's absolutely right. And I tell my clients that. I say, we can't put Walmart in jail. We can't put Abbott in jail. And this isn't the Wild West. I don't get to take the Abbott CEO out into the street and shoot him in the face. That's not how this works. The only way to get their attention is to hit them in the wallet. It's the only way to get their attention. It's the only way to effectuate change. And so you give a big enough number that gets their attention.
So, Booker Shaw, I know you can't talk about details of this case because you were yourself a part of this case. But there's a theory that helps explain how jurors get to these verdicts. Tell us this background here.
There is reptile theory, but to clarify something that Sarah mentioned, it was not that the plaintiffs claimed that there was some defect in baby formula, but that a premature infant should be fed mother's milk.
Period.
Period. Because when there is not mother's milk, then mother's milk has a medicinal quality to it.
Sure.
And so anytime the neonatologist chooses to use or is forced to use formula, because oftentimes for premature infants there is insufficient mother's milk, and so ultimately the neonatologist in many cases, has to decide, I've got to use mother's milk under these circumstances. So the argument or the claim that plaintiffs were making here was that the mother should have been fully informed of this decision. But there was not a claim that there was anything wrong with formula. It is well known that when you move away from mother's milk, that a premature infant becomes susceptible to a number of infections, including necrotizing enterocolitis. But I think what plays out in these huge verdicts, and I've been involved in a number of cases where this occurred.
Yeah.
And it's called reptile theory. And basically what happens here is that the strategy is one where the plaintiff's counsel tried to create an atmosphere where the jurors intensely dislike the defendant, portraying the defendant as a danger to the community itself. And so this theoretically activates in the jurors an instinct called reptilian instinct to protect the community and, the survival instinct. And so when it is used effectively, and I have certainly seen a number of instances where it is used effectively, jurors tend to disregard the science and decide that they need to punish the defendant with a huge verdict. But here, of course, it was even more effective because, as Sarah mentioned, you're talking about a severely injured baby that was going to require very expensive care and treatment for the rest of her life.
Yeah, I can understand the sympathy for this severely injured baby. I suppose that would bring out my anger at the reptile. The idea is we have to kill the reptile. I get how a person could get there. I still kind of wonder if I'm sitting on this jury, would I want to go after the manufacturers of the baby formula that has helped countless women be able to feed their babies? We can go back to work. We don't have to, not all of us have breast milk that's capable of sustaining life. This is this great option. Shouldn't it have been the hospital that administered it? That's the problem here. Bill, do we have the right reptile?
Well, I don't know, but I do know, as my recollection goes, that the Abbott manufacturing plants were found to not be up to snuff. They had conditions that the FDA said were shocking.
Now, my understanding is that's totally unrelated to this case, though. That was a different set of litigation over a different fact pattern years, at least a year before.
That was in 2022, and involved the Sturgis and plant, and also the Arizona plant that Abbott ran. The AP had quite a few stories about the conditions in those plants, and I read at least one story saying that the open cans involved in this case had showed some sign of the bacteria, while the sealed cans did not.
So when we're bringing in a reptile here, can we bring up things like this, like the unrelated problems Abbott had in a different case? Is that something a judge will allow in as we're on our reptile hunt?
Right. No, that didn't come into this case. Only in jury selection, when jurors were asked about it and if that might have an effect on their ability to be fair and impartial in this case. But it was so totally unrelated here because this particular infant formula, this premature infant formula, is not sold commercially on the shelves. It's provided to hospitals and for neonatologists to use under these circumstances.
It sounds like something, though, that if Bill were a juror, maybe if Bill was being questioned about this, he'd be like, yep, I'm ready to go get Abbott Labs. That might be a juror that somebody might want to excuse from this case.
Possibly.
So Abbott Labs made a statement here. They said there is, quote, no scientific evidence showing Abbott's preterm infant products cause or contribute to causing NEC. That's, again, the necrotizing enterocolitis. Specialized formulas and fortifiers, like the one in this case, are part of the standard of care by the medical community, and along with mother's milk and donor human milk, are the only available options to feed premature infants. Sarah, in this type of case where you have One side trying to create the reptile, the other side trying to hold a big corporation accountable. It seems like a lot of this comes down to what sort of experts does the judge allow? What sort of testimony can be entered into this? How fierce are those battles?
So I'm going to pick on my colleague Booker for a moment, because if you notice, the argument shifted from inconclusive, we don't know. I mean, and every defendant argues the science is inconclusive, therefore it's not probative, and therefore it should be excluded. And so the argument really shifted from it's inconclusive, the experts aren't right, there is no link, to Booker's argument, which is it's fine. It's the hospital's failure to warn. And so Booker's argument almost implies that maybe there is something wrong with it and it shouldn't have been given to the baby. The hospital didn't warn the mother. And my response would be, well, maybe the Abbott should have warned the hospital. Maybe there should be great big labels on the bottle. I don't know if there is. I haven't seen into evidence. But as far as your question as to experts, yeah, there's going to be experts, and every defendant claims the evidence isn't conclusive, but that's what Monsanto claims with Roundup and cancer. That's what the tobacco companies claimed with lung cancer. That's what Johnson & Johnson claims with the baby powder or the talcum. That's what every defendant claims, and it's inconclusive until it's not. And so I assume that the Abbott had good attorneys. I assume plaintiff had good attorneys. I assume there were very competent experts. I assume that both parties sought to strike experts. I assume those were denied. And then the jury gets to hear both sides. They get to hear, what do the experts say? What is in the formula, or what should not be in the formula? What should be in the formula? I don't know. I didn't get to hear all of it. But for me, hearing it, I say, if the judge didn't strike the experts and the experts get to testify, the jury gets to decide, is it inconclusive? Is it not? And so I wouldn't argue with this jury's verdict. I didn't get to hear all the evidence, but I think this verdict will probably stand. I assume Abbott filed a J&OV. I assume they're
Sorry, J&OV.
Sorry, judgment notwithstanding the verdict, which really is when the judge comes in after a verdict and changes the judgment or changes the order so that the losing party actually wins.
To say, if we're just looking at the law here, this was incorrect. You're
Right.
saying you don't think that will happen here.
I do not. I think it will probably stand with this judge. The Illinois Court of Appeals has gotten more conservative. I wouldn't be surprised if there were a reversal. I wouldn't be surprised. And then the Illinois Supreme Court is truly split down the middle. So,
And this is in Missouri.
Illinois.
No, this was in St. Louis.
Oh, I thought it was St. Clair County.
No, this was here in St. Louis. Yeah.
Oh, okay.
Yeah,
Well,
no,
then
the family
strike
was
all
from
that.
the Metro East.
Okay.
So I wonder if, we have a panelist frequently on this show, Eric Banks, who says, oh, they should just settle. Like, with the Missouri courts about to get involved, should they just settle? I don't know. This is a pretty big verdict. Do you think the Missouri courts would be likely to let it stand?
And J&OV, judgment notwithstanding the verdict, is a drastic measure.
Yeah.
It is rarely used. It can happen, but it's pretty rare. So, I mean, whether it's Illinois or Missouri, I would still be surprised. I would still be surprised if the judge yanked the verdict.
In this case, we have 9 out of 12 jurors. I think we've all seen the movies. We assume a verdict has to be unanimous. That's not the case for some civil claims here. Is that something that higher courts are likely to care about? Bill?
Well, they might pay attention to it in connection with, should the judgment be reduced. I really don't know.
Okay. So this was the first NEC case or NEC verdict against Abbott that came out in trial. Apparently there are thousands of similar NEC-related baby formula trials pending in courts throughout the U.S. The next state court trial is actually scheduled again to be in St. Louis. This is happening this next month. Booker, any thoughts on, are they picking St. Louis for a reason?
Yes, they are. But back to another thing is that there was never a claim really that there was something inherently inferior or problematic with the formula, or that the hospital should have warned. It was that Abbott should have informed the mother, or done a better job of informing the mother of the infant, of the risk associated with switching from mother's milk or even donor mother's milk 2 formula.
Yeah.
And that's the issue in the case. So it presents to me a somewhat unique legal theory. And so I can't really speak to some of this because of my involvement in the case. But yeah, there is a reason why St. Louis has been chosen. Some of the similar reasons why St. Clair County is being chosen by a number of plaintiffs' lawyers bringing these types of cases. Plaintiffs' lawyers believe that they have an advantage in St. Louis as they do in Madison County, St. Clair County, Philadelphia, and different jurisdictions. I don't know that is necessarily true in every case, but they have this perception.
It's interesting. Missouri Lawyers Weekly tallied these cases. They said that the city and county tallied 15 verdicts over $10 million in 2023. That was up 10 verdicts from the year prior. Sarah, your experience, do you think juries are starting to say, yeah, hey, let's give some bigger awards here. We don't like this reptile.
I don't think the awards actually are bigger, right? It's inflation. Time has changed. And I really despise the McDonald's case because the woman was severely burned and injured, and she got $10 million, and all of our jaws hit the floor. $10 million was just unthinkable. It's like when my mom tells me she used to get milk for a nickel, right? Like, times have changed. Things are more expensive. It takes more money to get their attention. This is not a new phenomenon.
Yeah. Bill, do you think we're seeing some escalation on these verdicts?
Well, I mean, this is an issue that's been around forever. The size of the verdicts in Illinois, in particular, and then more recently in St. Louis. I've actually seen some studies on both sides of that, so I couldn't say.
The American Tort Reform Foundation, they named St. Louis as number 8 on the annual judicial hellholes list. I have talked to some trial lawyers who have pushed back hard on that. This is one of these. I will probably be getting phone calls this afternoon from people telling me why that list is wrong. And I think that's something we should probably put it to a jury. Have a jury decide, are we a judicial hellhole?
That's a Chamber of Commerce run operation, isn't it?
There you go. Yeah, exactly. I mean,
tort reformers are complaining, right, about the city. They're not complaining about the federal courts as being hellholes, right? Because they're more likely to get a case dismissed. They're more likely to get summary judgment. So I am skeptical of the people doing the polling or creating the list.
It is an improvement, though. Not too long ago, St. Louis was number 1.
Is that right? Okay, we're slipping.
We're improving.
We are talking today to our legal roundtable. That is Booker T. Shaw of the law firm Thompson Coburn. We're also joined by Sarah Swadish of the law office of Sarah Swadish and Bill Freivogel, a professor of journalism at Southern Illinois University, Carbondale. We need to take a quick break, and we'll be back shortly here with our legal roundtable. This is St. Louis on the Air on St. Louis Public Radio. Welcome back. I'm Sarah Fensky. I'm here today with our legal roundtable. It's always so fun to pick the brains of people who are smart. I learned so much from these guys. And today, that includes Sarah Swadish. She's at the law office of Sarah Swadish, handles labor and employment cases. Also joined by Bill Freivogel, a professor of journalism at Southern Illinois University, Carbondale. And Booker T. Shaw. He's a former justice on the Missouri Court of Appeals Eastern District, also a partner at Thompson Coburn. And we're going to talk now about some matters of life and death. So 2 different men who've done a long time in prison and county prosecutors who sought to free them using the state's 3-year-old wrongful conviction law. In both cases, they ran into fierce resistance from Missouri Attorney General Andrew Bailey. Now, the first case was Christopher Dunn. Now, Booker, you played a key role in this case. You reviewed it at the behest of Circuit Attorney Gabe Gore. What did you find here?
We found that we had a very strong case for innocence. Fortunately, in this case, there had previously been a habeas corpus action down in Texas County, And Judge Hickel there went through all of this evidence, and of course all of that was admissible in our case. But it made it easier for us, Sarah, to go through that, the investigation they had done. The Innocence Project, of course, the work that they had done was invaluable. In addition, we were able to catch up with witnesses who were still available. It was just... Our case was a lot easier, I think, because it was on all fours with the Amrine versus Roper case, a Missouri Supreme Court case that defined to a certain extent what actual innocence meant. And our case, in Christopher Dunn's case, fitted all fours.
So this was a man who'd been in prison for more than 3 decades. And the the city prosecutor, Gabriel Gore, was able to pursue getting him declared innocent, that he was there, he did not do this crime. And yet it took a full week after that decision was made to actually get him out of prison. And that was because of Missouri Attorney General Andrew Bailey. He had some interesting legal arguments here in this case, and I was honestly surprised it took a full week to sort of work through them. Anything you'd want to say about sort of that back and forth of what it took to actually get this innocent man out of prison?
Well, we were so relieved once we received the court's decision, and we all felt that he's been locked up for all this time, and now that actual innocence has been proven, his release should be pretty immediate. And insofar as the Attorney General also had no right under the statute to appeal. As you may recall, the Missouri Court of Appeals dismissed it out of hand, and then they went to the Supreme Court, and it did cause us some concern. But it didn't take too very long. I mean, we were still concerned about the fact that the Supreme Court even entertained these arguments.
And slowed it down there for a little bit.
Yeah. It certainly took a lot longer than we thought it should have taken.
Man, if I'd spent 34 years in prison and I was declared innocent, I would say, let me out immediately. I would be so angry in that final week. Bill, do you think Attorney General Andrew Bailey acted appropriately to try to appeal this finding by the judge?
Well, as Booker says, the statute that was passed by the legislature after the Lamar Johnson case that Kim Gardner had brought, that it doesn't really give a role for the Attorney General to of this kind. And so I think I don't think he should have been involved in that. I mean, it seems to me that maybe it's just too simplistic to think that the Missouri Attorney General should be wanting to make sure that guilty people are behind bars and that innocent ones are not.
A little simplistic there, Bill.
I'm sorry.
So the second wrongful conviction case being pursued by a local prosecutor, this one, I think everybody agrees, is more complicated. This is the case of Marcellus Williams. This case has been a roller coaster. He has an execution date set for September 24th. St. Louis County Prosecutor Wesley Bell had fought to get a hearing to examine his innocence claim. That was supposed to be last Wednesday. And then things got complicated. Prosecutors huddled, emerged to say they'd reached a deal with Williams. He would enter an Alford plea. Sarah, what's going on? What's an Alford plea?
An Alford plea is essentially when the defendant says he pleads guilty, but he's not admitting he did anything wrong, but he is admitting that there's enough evidence there that he could be convicted.
Okay, so he enters this plea. This is after he was convicted of this crime years ago. Now he's always maintained his innocence. We get to this Alford plea. This ends up leading the prosecutor, Wesley Bell, to take the death penalty off the table. This is a deal that the victim's family wanted. Everybody seems to be happy with this. Again, the Attorney General's office not happy with this. Bill, what do you think of their actions on this one?
Well, I wouldn't be as critical of Bailey on this one. Although, again, what exactly are his statutory powers? That's still very much up in the air as far as I can see. But I mean, there is evidence that this defendant could be guilty. I mean, he was found guilty. The evidence that led to that finding is still out there. It hasn't been recanted as it had been in the Dunn case. So I wouldn't be as critical of Bailey in this particular case.
Booker?
Yeah, I was just going to add on to what Bill said. To be clear, in the Christopher Dunn case, it was the rare case where the only evidence was the recanted testimony of these two kids who were 12 and 14 years old at the time. So there was no other evidence of guilt in the case. And so under those circumstances, as I said, it fit the Supreme Court precedent, and I think it was an easier call. Where there is other evidence, then proof of actual innocence is going to be more difficult.
Yeah, so the wrongful conviction statute contemplates, quote, clear and convincing evidence of actual innocence or constitutional error at the original trial or plea that undermines the conviction. Booker, do you think the evidence now available to prosecutors in the Marcellus Williams case, does it seem to meet that threshold?
Well, I don't know what all the evidence is or was there, but I know there was other evidence. And so because this is a new area of the law for judges to have to grapple with, I think it's a more difficult call when there is other evidence. And as I said, in Christopher Dunn's case, there's a Missouri Supreme Court case that was directly on point that addressed his situation where the only evidence is recanted testimony.
Yeah, and in this case, I was just talking to former Chief Justice Mike Wolf of the Missouri Supreme Court. He pointed out you've got two people who testified against Marcellus Williams. Both of them at this point have passed away. You're not going to get a recantation here in the way that you got in the Christopher Dunn case. We don't know if they stand by their testimony. They didn't publicly recant before they died. Bill, this is tricky.
It is tricky. And then you also have the mess of involving the murder weapon and the DNA. Which, as it turns out, has, I guess, one person who handled it at some point or another was a investigator in the prosecutor's office. So
yeah, we thought this might be the big reveal. There was DNA on this murder weapon that wasn't Marcellus Williams. It was an investigator for the office.
Yeah, and so apparently the DNA test does not clear Marcellus Williams.
Yeah, so this does become a lot more complicated in this case. And the point that Andrew Bailey was making in this one, as he appealed to the Missouri Supreme Court to have this deal thrown out that would have spared the life of Marcellus Williams, is he's saying, hey, Wesley Bell brought this case saying this guy is innocent. And now he's coming back and saying, I formed a deal to take the death penalty off the table. It does seem like maybe there's a dual role here that doesn't make sense. Sarah, any thoughts on that?
It makes sense to me. I'm fine with the Alford plea. I'm fine with life in prison because he is admitting there is enough evidence there to convict him. I think a jury could go either way. They did find the laptops, the victim's laptop in his car. Right? So there is enough evidence there. I don't know if he's innocent, but I don't know certainly is not beyond a reasonable doubt. Right? And so I'm okay with the Alford plea and life in prison instead of the death penalty. But what I noticed Bailey is doing, he's telling the circuit court, you should disregard the hearing that Marcellus Williams is entitled to and proceed with the execution on September 24th, right? It's the same thing they did in the Johnson case. The Judge Ott in St. Louis County assigned a special prosecutor at the last minute because that's when they were finding the evidence. Special prosecutor came in, said, hey, don't execute him, pause it. Judge Ott says, I don't have enough time to be thorough. I don't know what to do. Denies it. Court of Appeals denies it. Gets up to Missouri Supreme Court, and they say, yeah, you didn't prove it by clear and convincing. Well, and the response is, well, we didn't have time. You didn't delay the proceeding. And so I think Bailey is just trying to push this through as fast as possible. He's trying to skip the hearing so that he can rush to execute.
Yeah, I talked to Bailey's spokeswoman, and she says, he believes in the finality. Jurors have made these decisions. He doesn't like to see them sort of be churned up after the fact, that our system is working the way that it's supposed to work. She also cited victims' families. Now, in this case, the victim's family, they want the death penalty off the table. So that's a little bit harder to make that argument.
Plus finality, Sarah. That given all of the cases where death row inmates have been found to have been wrongfully convicted that are in front of us in Missouri and in front of us in Illinois before the Missouri ones started popping up. I just don't know how you can rest too much of your argument on the finality. Those were all final, and they were all wrong.
Yeah.
There was Kevin Strickland in the Kansas City area. Joseph Amrine, you mentioned Booker earlier. I was writing an editorial to try to clear him in 2000.
Yeah.
And it took a long time. The finality that's not an argument that gets very far with me.
And I think Bailey's representative was a little bit more kind than Bailey's website. Bailey wrote on his website, instead of taking the opportunity to prove Marcellus Williams, innocent at the hearing scheduled originally, Williams instead tried to plead guilty to a crime he claims he did not commit. No innocent man is willing to spend the rest of his life in prison unless he knows he's guilty. And I had two thoughts to that. Well, the alternative is execution, and then even though we're going to touch it later, Bailey dismissed his lawsuit because he didn't want to sit for a deposition. And my thought was, Bailey, you should have sat for a deposition if you didn't have an ethics violation. So, and I know it's a little bit early, but it felt very hypocritical. Feels a little hypocritical.
Booker?
Well, yeah, and I think the point here, though, is that, number one, the prosecutor, there's a safeguard involved in that the prosecutor sitting in that jurisdiction brings this cause of action. Mm-hmm. So it's not as if the defendant hires an attorney to go out and do this. The prosecutor has done a significant investigation, and it's not like this prosecutor is a bleeding heart or against the death penalty. And in addition, the Attorney General's statement kind of misconstrues the Alford plea. The Alford plea is not an admission of guilt. Mm-hmm. It's an admission that the state has sufficient evidence to prove guilt.
Yeah, and so that's a very different thing, and it seems like he's kind of using it against him. Do you think Judge Hilton will be likely to have that same interpretation?
Well, Judge Hilton knows what an Alford plea is.
Well said. All right. We need to take a quick break here. But before that, I do have some breaking news. I want to cut into our legal roundtable to just briefly fill you in on something. A judge has removed St. Louis County Councilman Dennis Hancock from office effective immediately. St. Louis County Prosecutor Wesley Bell filed a quo warranto motion against the 3rd District Councilman. Judge Julie Lassiter issued the ruling this morning. KSDK reports that Hancock violated a nepotism clause when he hired his stepdaughter as an administrative assistant. Hancock has until September 17th to file a response. When we get back after the break, we'll talk about what a quo warranto motion is, because I have not heard that phrase since the days of Circuit Attorney Kim Gardner. This is St. Louis on the Air on St. Louis Public Radio. Welcome back. I'm Sarah Fensky. I'm here with our legal roundtable today. That is Sarah Swadish of the Law Office of Sarah Swadish. Also Bill Freivogel, professor of journalism at Southern Illinois University, Carbondale. And Booker T. Shaw, who's a former justice on the Missouri Court of Appeals and is now a partner at Thompson Coburn. So right before the break, we got some breaking news that a judge is removing or trying to remove St. Louis County Councilman Dennis Hancock from office. And this comes after St. Louis County Prosecutor Wesley Bell filed a quo warranto motion. I'm sure I'm mangling the pronunciation of that. Booker, what do we know about these quo warranto motions?
Well, we know that the quo warranto is a motion or procedure by which the prosecutor can attempt to remove someone from office, as was used against Kim Gardner. And what we don't know yet, we don't have all the facts at this point as to whether or not this council person has resigned or was removed, typically a hearing is required, as was contemplated in the Kim Gardner case. We never got to a hearing there because she resigned. But I would assume that the judge is setting a hearing to determine the viability of this claim.
So this is something we'll probably be hearing much more about, I suspect even later today, the fate of St. Louis County Councilman Dennis Hancock. In the meantime, I want to talk about a case that got a ton of headlines in this past month. A transgender woman's use of an Ellisville gym became a major flashpoint. The woman was using the female locker room, had a driver's license saying that she's female. Other guests complained about her presence. Protesters came out. Andrew Bailey, we seem to be talking about him a lot today, the state's attorney general, launched an investigation. The gym says, hey, we're just trying to follow the law here. Bill, what does Missouri law say about access to amenities like locker rooms for someone like the woman in this case?
Well, it would be, there are, I don't know exactly what Missouri law says in connection with that. I do know that this whole area of when excluding a transgendered person from facilities is a violation of federal law is a big issue that is that's involved in a lot of different cases. Cases involving the Affordable Care Act, to what extent are Biden administration regulations that say you can't discriminate against transgender people, or to what extent are they enforceable? Same thing is occurring in Title IX in higher education. Biden administration regulations saying that you can't discriminate against a transgender person in higher education programs. The Supreme Court has got a case this fall from Tennessee. Tennessee has a law against providing transgender treatment to teens. The Supreme Court's going to be ruling on that. So as far as this particular case, I think that the gym was perfectly within its wasn't violating any law to allow a transgendered person to use its facilities, and that, in fact, had they denied her access, that they could have been running into difficulties.
We heard from a number of listeners with thoughts on this. Laura writes on X, the incident at Lifetime Fitness started because a trans woman who had a valid ID used the women's restroom. How can State Representative Justin Sparks justify rallying a mob for a press conference when that's the only information he had access to? Jeanette writes, quote, is it the job of Missouri politicians to organize mobs to harass citizens? We also have Jerry calling from O'Fallon with some thoughts on this. Jerry, hi, you're on St. Louis on the Air.
Thank you. There's a lot I wish I could say about this, but it wouldn't make it past your delay. But I think this is kind of a perfect example of what a clown show our state government has become. And I know this is not limited just to Missouri, but what I really can't understand is the people that this excites, for lack of a better term, them towards action with all of the really critical issues that we have going on in our state and really in a lot of places. I can't believe that someone feels that they can justify using resources for such a trivial event. And I guess it just kind of plays into their political popularity.
Jerry, I want to thank you for that call. We have the state attorney general getting involved in this. And as Bill pointed out, this gym would be damned if they did, damned if they didn't. It doesn't seem like there's much of a legal issue here. Well, the gym did later revoke the woman's membership over social media posts they said could affect the safety and security of the club. And then soon after that, Missouri made it harder to change your gender identity on your driver's license, something that seems to have followed this controversy. The state switched from requiring the signature of a physician, therapist, or social worker to approve a change in gender designation to mandating documentation of gender reassignment surgery or a court order. Sarah, you're a labor and employment lawyer. Do you think this is going to make change anything for people with these kinds of claims?
The individuals are just going to jump through more hoops, right? There are individuals who will go through reassignment surgery and it'll just be another form they fill out. It might be annoying, but it'll be fine. The people it will truly affect are the people in the middle who are maybe taking hormones or who have just begun the process, haven't had surgery or don't want the surgery. It will affect them the most. I think the Department of Revenue has the right to do it. They have the right to do it, but I don't think outside of annoying and harassing the people that affects, I don't see a huge impact on the workplace, on driver's license that people submit to verify their identity. I just don't see it having ramifications.
I mean, the big issue that we're going to hear over and over again is discrimination against a transgendered person. Is that sex discrimination? The Supreme Court said 4 years ago in Title VII, that's employment discrimination, that it is. Justice Gorsuch wrote the opinion. Now we got to find out, so what about in the context of medical care? What about in the context of higher education? And those are cases yet to be decided and are very much sort of on the bubble. We'll see whether or not the application of sex in Title VII is interpreted the same way in Title IX for higher education, the Affordable Care Act for federal payment of medical bills.
Yeah, so here's another case where another area where the law is sort of still being written. It gives you some sympathy maybe for somebody just trying to run a gym, and the next thing you know, there's politicians holding press conferences outside of it. Booker, any thoughts on this case?
Well, I agree with Sarah that all I read about were these kind of salacious accusations that amounted to some kind of indecent exposure or trying to make claims along those lines. And so I didn't see anywhere that indicated that the gym had done anything improper or illegal, and they were following the rules as they should have.
So we have big news for Missouri from the Eighth Circuit Court of Appeals. The Second Amendment Preservation Act is unconstitutional. That's according to a 3-judge panel in a circuit not known for being particularly liberal. Bill, are you surprised that they have said that this Missouri law, this cannot stand?
Didn't surprise me one bit.
I think you called this maybe 2 years ago on this show.
I think I did. A violation of the Supremacy Clause. Federal law trumps and the Constitution trumps state law, this is. And the other reason it didn't surprise me is that Bailey went to the Supreme Court last October and said, "Let us enforce the Second Amendment Preservation Act while the courts decide this case," and the Supreme Court said, Yeah. So that showed right off the bat there's he can appeal the Eighth Circuit opinion. He can go to the circuit en banc and say, "Why don't you hear this, all of you judges?" And he can go to the U.S. Supreme Court. But I think that what was said last October by the Supreme Court would make that a fool's errand.
Yeah, it made clear they're not that sympathetic to this. And we should remind people, this particular law that was declared unconstitutional, it basically said that local law enforcement cannot do any work involving federal gun laws. Sarah, this felt like one where on its face, everyone is saying, yeah, that's patently unconstitutional.
Yeah, and it wasn't simply the state officials weren't allowed to. It said the state officials weren't allowed to enforce federal gun laws, and if you did, it was a $50,000 penalty. It's never going to fly. I don't know. I mean, I understand why the politicians passed this bill, and then the Department of Justice intervened and sued, but Bailey would not be wise to take it to the Eighth Circuit. They will smack him down. And the analogy I had in my head is, let's assume Congress outlaws abortion in every form, medical, surgical, every form, and the state of New York says, no, we're going to permit abortion up to 16 weeks, and any doctor that refuses to prescribe the pills gets fined $50,000. People certain people would lose their mind. I mean, it's the same concept, the state coming in and saying, it's not that we ignore your laws, it's we're affirmatively and punitively making you enforce them. It's kind of like, I look at it like marijuana. Federal laws don't permit marijuana. States do. Federal government kind of turns a blind eye, ignores it, but not with guns, not with abortion, not with a lot of big issues. Federal government is not going to allow the states to come in and trump them.
The other thing about this decision of the Eighth Circuits is first of all, two of the 3 judges were appointed by a president named Bush. One the first Bush and one the second Bush. Second thing is that Missouri had tried to use that sort of Texas approach to abortion of having the law enforced by private individuals. And they said private individuals can have this cause of action against, say, the local police if they're trying to enforce federal law. And the Court of Appeal said, no, you can't do it that way either.
So in our final couple minutes here, I got to bring it back to Attorney General Andrew Bailey. Apparently, we haven't talked about him enough this month. I'm sorry, but he was supposed to sit for a deposition this month. Now he won't. A judge had ordered him to sit for a deposition in a Jackson County lawsuit filed by his own office. Bailey had accused officials of failing to follow proper procedures when they assessed property values last year, and that case was at trial. But Bailey was supposed to testify under oath about his communication with the Jackson County executive. Instead, he suddenly settled the case. Sarah, what do you make of that timing?
Well, I would use his own language about Marcellus Williams. If he were innocent, he would have sat for that deposition. I mean, so the circuit court compels the deposition. He appeals it to the Court of Appeals. They strike it down and say, no, you have to sit. And then literally within 24 hours, he dismisses the lawsuit. He doesn't want to sit for a deposition.
And yet there might be a more charitable interpretation of this one. Booker, what's the backstory on this lawsuit?
Well, not that I completely disagree with everything Sarah has said. There certainly is an element of suspicion involving it, but I thought that my understanding was that the tax commission had ordered the valuations rolled back. So as a legal matter, I'm thinking, putting my old judge hat on, is that if I were the judge there and the valuations are rolled back, they're not going to go into effect, then it renders the issue moot, and it might have been dismissed anyway, but perhaps I'm misunderstanding, sir.
I think the most charitable thing I could say is he won his primary election on Tuesday and dismissed the lawsuit Wednesday.
That's some interesting timing there. I have to wonder, though. I mean, I assume everybody here in this room has been under deposition at some point. What's the big deal about being under deposition? Why would he try so hard to avoid this that he'd get a damning headline out of it? Sarah?
It's under oath. And you're gonna get in trouble. Trump refuses to sit for a deposition and he refuses to testify at trial, right? Because it's under oath and it has real ramifications. You can say anything you want on Twitter. You've got privileges to file things in court with pleadings, but once you're under oath, they're going to pin you down on something. And it may be something trivial like the blue dress Bill Clinton had, but it's going to be something. They're going to pin something. They're going to nail you down on something, and you may not be able to wiggle out whatever it is.
Bill, in our final minute here, so this is something no politician should want to sit down under oath. They might be able to just find something that can later bite you.
Well, I guess you want to avoid depositions. And certainly, we've seen some of Trump's depositions saying that were sort of embarrassing. But Andrew Bailey, I just takes a lot of these things too far. Just earlier this month, in something didn't get noticed much, he went to the Supreme Court to say that he wanted to be able to sue New York to get rid of the gag order on Trump so that his clients, his constituents in Missouri would have the advantage of hearing from Trump. The Supreme Court didn't take long to say, see you later.
Can't say I'm too surprised.
No.
The Supreme Court wasn't into that one. We'll see what he comes up with next month. He always gives us a lot of fodder for the show. I should thank him. Bill Freivogel, I'm also going to thank you. Thank you for joining us today. Bill is a professor at Southern Illinois University, Carbondale. Sarah Swadesh of the Law Office of Sarah Swadesh, thank you for joining us.
You bet.
And Booker T. Shaw of the law firm Thompson Coburn, thank you so much for joining us.
Thank you, Sarah.
This episode was produced by Sarah Fensky.
Our audio engineer is Aaron Dorr. This podcast was mixed and edited by Aaron.
Our executive producer is Alex Hoyer.
St. Louis on the Air is a production of St. Louis Public Radio. Understanding starts here.
Do you find yourself regularly listening to episodes of St. Louis on the Air? Suggest us to a friend you think might enjoy our conversations. And leave us a review and rating on Apple Podcasts on the App Store. It's the simplest way to help people discover our show. Thanks.
St. Louis Public Radio is a member-supported service of the University of Missouri St. Louis.
The Gateway brings you the day's news each weekday from around the St. Louis region and the state capitals in Jefferson City.
Our schools are accredited. We don't need this bill.
And Springfield.
How many more years must pass before lawmakers see time is of the essence?
I'm Abby Larico. Join me each weekday for The Gateway on the STLPR app or wherever you get podcasts.